Hello and welcome to this session entitled Contract Law, Formation, Exclusions and Boilerplate. My name, as you can see, is Keith Markham and I will be your presenter for today. Let's begin, as always, by looking at the agenda. So let's get that up in front of us in just 1 second. So the agenda is as follows. We're going to begin by talking about contract formation. We're going to look at issues around subject to contract in particular. One case where subject to contract was used, what was the impact of that? Another case where subject to contract was not used, what was the impact of that? And we'll see what the case law had to say on that. Then we'll move on to really quite a fascinating case, or at least I think it's fascinating, to do with the issue of Battle of the Forms. And of course, we all know that the traditional analysis with Battle of the Forms is last shot wins. However, on this particular occasion, we will see that the first shot won due to some clever contract wording that you might consider adopting for yourself. Then, of course, a perennial favourite on these particular courses, the issue of exemption clauses. So we will look at two cases. The first one is to do with the application of the test of reasonableness. That, of course, is Schedule 2 of the Unfair Contract Terms Act 1977. And the second case is an issue of interpretation in terms of whether the clause in question or the clauses in question can exclude or restrict liability for loss arising from a deliberate or indeed intentional breach of contract. What else do we see then after that? Well, let's have a look. We will also then move on to talk about subject to consent. I'm sure we're all familiar with that particular wonderful phrase. We agree to do this subject to our consent, not to be unreasonably withheld or delayed. And maybe you've never thought about what the case law says about that. Well, today I will show you the two most recent cases that give you a flavour as to when you can withhold and what we mean by reasonable in the circumstances. Then we'll go on to another perennial favourite of this particular course, which is notice clauses. And it's surprising how little care and attention is given to the drafting of those clauses, and even more to actually complying with their particular requirements, as we'll see a little bit later on. Penultimately, we'll look at severance. So as we are aware, the court has the power to sever offending content. Often they'll do it by removing a clause in its entirety. However, many of you will know that there's something out there called the blue pencil test, whereby a court can remove an offending word or an offending phrase and allow the rest of the clause to survive. And we're going to look at the circumstances within which that will happen and a recent case that shows us what the court's thinking is. Finally, we're going to talk about variation. Again, a very bread and butter issue for lots of lawyers, whether private practice or in-house. The reality is that it's something we need to make sure we get right. And yes, a letter of variation or deed of variation is fairly simple to draw up, but you need to make sure that you comply strictly with the content of the variation clause. And that is where we can come unstuck, as we'll see at the end of this session.